the protections that are built into the tariff that governs FG&E as a utility subject to regulation by the Department of Public Utilities. There are protections, limitations of liability built into the tariff which acts with the force of law that protects and completely bars this type of a lawsuit from going forward. They would like you to ignore that. They would like you to do that even though there's no Massachusetts case standing for that proposition. So you would be the first jurist in Massachusetts to allow this kind of a lawsuit to go forward. They want you to do that even though there's a full-blown regulatory proceeding that's pending right now and has progressed quite extensively, dealing with the very same issues that are being complained about here. They want you to do that despite the fact that in that full-blown regulatory proceeding, the Attorney General has appeared in her capacity as consumer advocate on behalf of the very plaintiffs who purport to be part of this lawsuit here today. And in that proceeding, she is seeking fines and penalties. They also would like you to do that despite the fact that the result of all this would be a flood of cases against utilities who have interruption of service as a result of storm. Lawsuits that have never been in the courts before would flood the courts and in essence increase the operating costs of the utilities and therefore the rates that will be paid by the very consumers that they represent.
I would simply ask you to take a look at the SJC's decision in Share versus Brandeis University. It's cited in our letter with the briefs, and it's cited, I believe, in both memorandum of law by the defendant and the plaintiffs. And it simply stands for the proposition, apart from judicial notice, that if the public records are material and can assist the court in deciding the issue before it, the court has the discretion to look at the documents. You can either decide to do that or not. I don't think it's a deal breaker.
Rule 12 in your motion?
Yes, because don't forget, the defendants have raised in their motion the alleged heightened standard of pleading in a motion to dismiss context in the SJC's decision last year in Ianchino versus Ford Motor Company. And my concern, our concern was that, the complaint, the First Amendment complaint, I think, is very extensive, Your Honor. It has 83 paragraphs to it. As part of 4 counts, there's extensive recitation of facts that are common to all 4 counts of the complaint. So I think it's very thorough in and of it itself. Nonetheless, insofar as some issues are being raised by the defendant in their motion, which may have bearing on the proceedings before the DPU, which again, they're relying on the DPU and the tariff in their arguments to the court, saying that there's an exclusivity about them that prevents the plaintiffs from stating a claim as they have in this complaint. So all we're asking you to do is to consider the DPU hearings as they proceeded in the context of the argument that they're making.
That $4.6 million, even if they have to pay it, goes to the general fund. Not one penny goes to these consumers, the 28,500 people.
Can the Attorney General in that proceeding seek damages on behalf of the consumers?
No, they cannot. The only way they can do it in court, they piggyback, Judge, I should just, because I know you don't know this, but they piggybacked on our complaint, not the other way around. We had filed our complaint prior to the Attorney General taking an active position. And just to address a few other things that my brother talked about, he says they had public hearings for all of the utilities. That is absolutely true. I think 10 people came to the hearing in Worcester, 8 of which worked for the company. There were two or three consumers there, and they spoke in favor of the company.
Which hearing are we speaking?
This is when they had public hearings in Worcester for a different utility, not for Fitchburg Gas.
Okay, let's just focus in on this case and these hearings, because I think that's really what we're...
There were 8, my brother talked about this, it's the only reason I'm responding to it. There were 800 estimated people that came to the hearing in Fitchburg, and there were 400 estimated people that came to the hearing in Lunenburg. This was unprecedented in the history of the DPU. They have never seen this kind of a public response. And I think that's very, very important. I was there, I know Attorney Altman was there, and some of the attorneys representing Fitchburg Gas were there. The outrage was beyond belief. We did attach, we made reference to that, Your Honor, in the complaint, and we did attach those public hearings. They were not available at the time, We did attach them as in the exhibits which we had sent to you in terms of opposing this. So the worst case scenario, even if I think you have to look at this in the terms of judicial economy and so forth. The worst case scenario is we'd be allowed to amend the complaint and make those attachments part of the complaint. Even if you dismiss it, it would be dismissed without prejudice. And that's foolish at this stage of the game.